Arrest without a warrant. Arrest without a warrant. We have already seen the necessity of making an arrest without a warrant under emergent circumstance. Emergent circumstance full stop power to arrest without a warrant are mainly and widely confirmed confirmed on the police, but in some circumstances these are confirmed on other also. A police officer may arrest without a warrant. Without a warrant, any person actually concerned or reasonably suspected to be concerned in a cognizable offense. Cognizable offense हो गया. Cognizable offense B. Any person who in the presence of such an officer has committed or has been accused of committing a non-cognizable non-cognizable offense refuse to give this true name or residence. Full stop. In such a case, arrest is to be made for the purpose of the ascertaining the name or residence, and after such ascertainment the arrest person is to be released on this executing a bond with or without surety to appear before a magistrate if so required. Full stop. If such ascertainment or execution of bond could not be heard within 24 hours from the time of the arrest, the arrested person shall be forwarded to the nearest magistrate giving nearest magistrate having jurisdiction हो गया having jurisdiction. See, any person concerned or reasonably suspected to be concerned in any act committed at a place outside India, which if committed in India would be punishable as in offence for which he would be apprehended liable to be apprehended or detained in custody in India. Detained in custody in India. Full stop. D. Any person for whose arrest any requisition is received from another police officer competent to arrest that person without a warrant. Any person for whose arrest any requisition is received from another police officer competent to arrest that person without a warrant. A. Any person reasonable suspected of the being a dissector from any of the armed force of the Union. Armed force of the Union हो गया. Armed force of the Union. F. Any person found in possession. Any person found in possession of any complement, any complement of house breaking without any lawful accuse. Any implement of house breaking without any lawful accuse. Lawful accuse. G. Any person found in possession of the property reasonable suspected to be stolen and who may be reasonably suspected of the having committed in offense with reference to such property. Full stop. In any person obstructing a police officer in the discharge of this duty. Full stop. I. Any person who has escaped from the lawful custody. Full stop. J. Any release convicted committed a breach of any rule made under section 356 clause 5. K. Any person designed to commit a cognizable offense which cannot be prevented except by the arrest of the such a person. The Code of the Criminal Procedure amended Act 2008, Act 5 of 2009 has brought in substantial change in substantial change in the law related to the arrest. Full stop. Clause A and B of the section 41 clause 1 of the code has been amended to define the situation in which a police officer may arrest without warrant. Police officer may arrest without warrant. Full stop. Has per the new scheme, in addition to situation mentioned in clause C and 2I of the section 41 clause 1, a police officer may arrest without warrant where a person has committed a cognizable offense in the presence of the police officer. In the Where a person has committed a cognizable offense in the presence of a police officer. B. Where a reasonable complaint has been made or credibly information has been received or a reasonable suspicion exist that a person has committed a cognizable offense punishable with imprisonment for a term which may be less than 7 year or which may be extended to 7 year, may be extended to 7 year, may be extended to 7 year. C. Where a credible information has been received. Where a credible information has been received that a person has committed a cognizable offense, punishable with imprisonment for a term which may be extended to more than 7 year or with death sentence, and the police officer has been reason to believe on the basis of that information that such person has committed the said offense. In the situation mentioned at B above, the police officer shall proceed to arrest without warrant only if he has reason to believe on the basis of the complaint, information or suspension that the person has committed the legal offense. Full stop. Before making such arrest, the police officer shall also be satisfy himself as to following situation. A1, that the arrest of the person is necessary to prevent such person from committed any further offense, or arrest of the person is necessary for proper investigation of the offense. Over third, arrest of the person is necessary to prevent such person from causing the evidence of the offense to disappear or tampering with such evidence. Over fourth, the arrest of the person is necessary to prevent him from making any inducement threat or promise to making any person reacquainted with the fact of the case so as to dissuade him from disclosing such fact to the court to the police officer. Over 5, the arrest of the person is very much necessary to ensure this presence in the court when it is so required. Full stop. While making an arrest in the situation mentioned in clause B above, the police officer shall also be record the reason for making such arrest. Full stop. As per the new subsection 2 subsection 2 of the section 41, which has been substituted by the Code of the Criminal Procedure Amended Act 2008, a person concerned in a non-cognizable offense or a person against whom a reasonable complaint has been made or credibly information has been received or a reasonable suspicion exit of this having so concerned shall not be arrested without a warrant or order of the magistrate. Full stop. In all case where the arrest of a person is not required under subsection I of the section 41, the police officer may issue a notice directing the person against who a reasonable complaint has been made or credibly information has been received or a reasonable suspicion exist that he has committed a cognizable offense to be appear before him or at such other place as may be specified in the notice where such person failed to be comply with the term of such notice it shall be lawful for the police officer to arrest such person. Full stop. This power is whoever subject to such order that may be passed by court of the competent jurisdiction. Competent jurisdiction हो गया. Competent jurisdiction realizing that arrest bring humiliation and cruelty freedom the cruelty freedom the Supreme Court. Cruelty freedom the Supreme Court called for a change in the police practice in enforcing section 41 CRPC. Full stop. The court issue the following direction. Court issue the following direction. All the state government to construct it. All the state government to construct it. Police officer not be automatically arrest when a case under section 498A. 498A. All the state government to construct. All the state government to construct हो गया. All the state government to construct. All the state government to construct it. Police officer not be automatically arrest when a case under section 498A IPC section 4 of the Dowry Provision Act 1961. Dowry Provision Act 1961, but also such case where the offence is punishable with imprisonment for a term which may be less than 7 years or which may be extended to 7 years, whether with or without. Whether with or without again. Whether with or without fine is registered but to satisfy himself about the necessary for arrest. Necessity for arrest under the parameter laid down above following from the section 41 CRPC. Section 41 CRPC. Second, all police officer to provide with a checklist containing specified subclause under section 41 clause 1 subclause B clause CRPC. Third, police officer shall forward the checklist duly filed and furnish the reason and material which necessity the rest while forwarding pursuing the accused before the magistrate for further detention. Further detention हो गया. For the magistrate while authorizing detention of the accused shall pursue the report furnished by the police officer in term of the aforesaid and only after recording it satisfaction the magistrate will authorize detention. हो गया. Detention. The decision not be arrest in accused be forwarded to the magistrate within 2 weeks from the date of the institution of the case with a copy to the magistrate which may be extended by the superintendent of police of district for the reason to be recorded in written notice of the appearance in term of the section 41A CRPC be served on the accused within 2 weeks from the date of the institution of the case which may be extended by the superintendent of police of the district for the reason to be recorded in writing in unuseful situation created by the unlawful arrest of a magistrate by the police has made the Supreme Court issue the following guideline to be followed by the state government and high court while effecting the arrest of a subordinate judicial officer. If a judicial officer is to be arrested for some offense, it should be done under an invitation to the district judge over the high court, as the case may be. If the fact and circumstance necessity the immediate arrest of the judicial officer of the subordinate judiciary, a technical or formal arrest may be effected. C. The fact of a such arrest should be immediately communicated to the district and session judge of the district concerned, and Chief Justice of High Court. Chief Justice of High Court, okay, Chief Justice of